when he might be required to do so. I attached the prior submissions I have sent to Federico for your review. I have both jabs of the proceedings in the municipal court on April 25th, 2019, and August 2018.
Hello.
Where Federico violated the judicial code as well as other duties, including his oath. The transcript of the April 25 event is at this point being prepared. At this juncture, I believe it is more than reasonable to have a sit-down conference where all can look into the eyes of each other and determine that there is good faith on all sides. I have spent much time presenting a proposed settlement that is attached to this letter and in addressing the issues directly with Federico. My last two complaints to the NCJD resulted in letters of caution to two district court judges. So I do not make frivolous complaints. What Federico did in open court on April 25th to order me out of court within 10 seconds under threat of jailing for coming to the firm's office and leave a letter asking for settlement of issues is blatantly wrong. While it is appreciated that Federico did call me to seek resolution is fine, there must be follow through. If one is invited to the dance but ignored once at the dance, does the tree falling in the forest make a sound? Mixed metaphor intended for calm.
Oh no.
Question mark?
Yeah, question mark.
Yeah, that one fell flat. I think. So then we go to the next page.
Thank you, Candy. I haven't even said anything yet.
I'm still very much ready and willing to negotiate with Federico. At this point, I must see a good faith gesture. I have been left for the first waltz and have not heard any tree fall.
Seems to be a follow-up on that joke.
I guess so. It's bizarre.
Oh no.
And so before that, he's indicating, I am much ready and willing to negotiate with Federico. And then he goes on into the next paragraph, starting I am. What is that?
I am very flexible and I'm willing to meet at almost any time and place with Federico and or his attorney that is wished as I place this process as a high priority on my long list of things to do. Time is of the essence. However, if a date is set timely, I can work with reasonable settings. I will need a response within 1 week. If the firm has any say-so in this process of settlement, due to any pre-existing employment agreements and any controlling clauses therein, I would hope that Federico is encouraged to do a quote sit down end quote with Kim by the firm if that is within their authority to so encourage under any employment agreement or clause therein, either express or implied. Please look at the attachments and know that this is serious. I really want to be forward-looking and that I want to deter wrongful behavior in the future by Federico to the benefit of all. Dated this 16th day of May, 2019. Signature line for Kim Blandino Pro Se, his address, telephone number, and the earthling email address, along with the certificate of service that he does with apparently all of his documents.
It says, certificate of service, Kim Blandino Pro Se hereby certifies the service of the foregoing letter with complaint and attachments was personally emailed to.
That's the board of directors, my bosses. That's Jim Olson, Walter Cannon, John Wormley, and I'm guessing the secretary. Peter Angulo, Mike Stabersky, and then myself. And the email addresses are all law office addresses.
And then again, indicating that it was done on 16th of May, 2019 by Kim Blandino.
That's correct.
Okay. And further, the letters that he attached are included thereafter. Is that right?
Yeah, the ones that I believe read before.
Yep. So we have the one that was sent to you on May 9th, 2019, but dated at the top, May 8th, 2019. Is that right?
Yes, sir.
Thank you, Paul.
With the exhibits that he had attached to that letter, is that right?
I believe it was all the same ones, yes. And that federal case against somebody else.
Right. And then the document where he makes his original formal request of you that he entitled settlement agreement and release, that was attached as well, is that right?
Yes.
and the exhibits that he had sent to you later on,
That's correct.
which included the letter he dropped off at your firm on April 25th, 2019,
Yes.
and the exhibits to that letter,
Yeah, those strange exhibit numbers. Yes.
which included that customer feedback form we've gone through.
Yes.
I'm confused. Did they recall this witness?
And the Veterans in Politics letter,
Yes, all that, yes.
I think
and the letters from the Commission on Judicial Discipline,
Yes.
I think so.
Yes.
and the next exhibit, which was.
That's what I'm intending to do.
You wrote at your office on April 8th, 2019.
Yeah, that was the first surprise visit.
So in the letter to your board of directors at the law firm that you work for, in your private capacity as a lawyer, he sent all of the communications that he had had with you up until that point in time.
Correct.
This board of directors, Jim Olson, Walt Cannon, John Gormley, Peter Angulo, Mike Sapersky, their decisions have an effect on your career and your livelihood.
Of course.
In what capacity?
Well, I mean, they make the decisions with hiring, discipline, terminations. They're well-known, all of them very well-known in the legal community.
So,
It's
potentially,
a small legal community too, so.
so potentially it could lead to you losing your job.
Of course,
It could lead to you being humiliated.
of course. That already was humiliating, just having them see any of this stuff.
Do you notify the detectives that were involved in the investigation after seeing that?
You know, as soon as I received it, I can't tell you if I saw it right away or a couple minutes later, but I.
Thank you.
saying, here we go, and, you know, this is a real problem, we gotta do something.
Okay. Did the detectives indicate to you that it was time that you could now, if you
Okay, I just have to pause for a second. I'm a little confused. I was doing this late last night with Natalie. This witness was called, and I don't know why he's on the stand now. And I'm on it. Here's what's going on. I was going to go on with Artie tonight in a couple hours, and I thought, all right, I'll try to catch up on the trial and watch a little bit. And then my next thought was, well, if you're going to watch it, you might as well just stream it. And thank you all for coming out. That's really cool. This is interesting because Natalie and I were talking about this yesterday. They're trying to make the elements of extortion, and what they're trying to say is Blandino's actions could cause this guy trouble, which is the exact intent of it. They're doing a great job of it right here, but I'm confused as to witness because this guy was called a while back. I don't know why he's back on the stand. So if somebody can tell me, so I can figure it out. I hope I'm not on the wrong day, but it looked like it was live. All right.
wish to file for protection order against Mr. Blandino.
I just didn't want to talk over the trial as I said that. Sorry.
I'm not sure, but it was in, I think, email format where they said there was enough evidence.
Thank you, Marlon.
Go ahead and do what you need to do in the meantime because right now you're there.
And they were still working on the investigation, but they wanted you to be protected.
Correct.
Okay.
They knew all along. I mean, I was jumping up and down. Like, I got to do something. I mean, all this investigation is great, but bottom line is, you know, I'm out in the open. Everybody else I know is out in the open. Hoping somebody can do something, but they have to do their investigation. And for me to do anything sooner could have interrupted that investigation. That's kind of the way it works.
I did not do that to the audio. It just went off a cliff. I didn't do anything, I swear. Pick it up with Alex. Okay, Beth.
Ultimately, all of this comes to an end in regards to the investigation and things that way.
Yes,
Oh, no.
Filed against Mr. Blandino,
yes.
and that happened shortly.
Is there a show
after
called Super Nanny? For reals?
that letter was received by you and the Director
I faulted.
of the law firm.
Yes,
And that's what now has you up here on the stand testifying today.
that's correct.
Okay. Save and pass the witness.
Cross-examination.
Can you guys hear anything? It's so low. No, he's also got a red t-shirt apparently. The whole dance analogy thing was really getting me. It was delicious before the audio dropped. So that, oh my God, we're just getting to Ben's cross of this guy? I do think that last testimony was really effective in meeting the elements of the case. I really do.
Will you justified on direct examination? Obviously, that you are.
You beat me, Fulgent. Mine just shipped. That's awesome. I need a picture.
Pro tem, you're a full-time attorney with a civil case law.
Civil
Thank you,
case,
Jeff.
Civil litigation law firm, primarily.
What is that? You and I obviously in the legal field. Can you explain maybe just a little, as brief as possible, what civil litigation is? What does that mean?
This is where people or entities or a mixture of both have claims against one another. In other words, it's a plaintiff and a defendant, co-defendants, as opposed to state versus Blandino, that kind of thing. So it's basically, it could be government entities too, in other words, state of Nevada versus Clark County. But it's usually suing for like money, things like that, as opposed to being charged and possibly facing jail time. So civil doesn't have anything to do with the jail time.
Right. So, for example, so your clients. wouldn't
Thank you, old
necessarily
dog.
go to jail, they would maybe owe money for breaching a contract or something to that.
More in the lines of injury, in other words, like if you fall at Caesar's Palace and you sue, then maybe I need defending.
Oh, Lord. We're describing civil litigation. It's litigation where you're seeking money damages as opposed to putting somebody in prison. Real simple.
And, all right. And, so, I mean, it's.
I'm going on with Artie later.
You said, so you're suing for money, so you're like negotiating.
This is my prep
with
session. I
other,
just streamed it.
Other entities or people all the time. Is that accurate?
For money, yes. I mean, it's usually money, or if it's a casino, it could be somebody looking to bump their player's card, things like that.
Oh, yeah, that's,
It just negotiations usually within the realm of money, at least in my job. I don't know what other people do. Not too much, not really that many contractual matters. Unless it's like indemnity agreements. Some things we don't need to talk about. It's too complicated.
Where are we going with this?
Yes.
okay.
He deals
So-
with torts
so
as
you-
opposed to contracts.
you've
Okay.
Done sort of negligence claims, is that?
Negligence and intentional torts.
Okay. All right. And, now we,
Oh, thank you, Leanne.
we saw, obviously, we went through the video of we saw the video of the traffic trial in,
Man, I got to come open some gift bags with you.
Well, you did mention that there were people.
Look at some makeup stuff.
behind the bar. Right, when you, those are people most likely waiting to have their case heard.
I saw that, and I also saw a few attorneys that I recognized were appearing in front of me, or just know, yes.
Thank you,
And
Paul.
the police officer that actually testified in his trial. So there were multiple people around coming and going.
I don't know what to do.
Because there's a lot of cases. Really, Alan,
But it's also, I mean, the courtroom is open to the public as well.
yes.
Okay. And really, I mean, as long as someone's not disruptive, they're welcome in the gallery of the court.
Agreed.
And, in
Being
that,
paid by taxpayers, so, you know, generally speaking, how people just start excluding people randomly without, cause. So I agree.
all right, and so I just.
Oh, thank you, Jennifer.
Some of my notes here. Okay. I know that one is, in that, the trial, you noted that, Mr. Blandino, prior to that trial, had filed a motion. Can you just maybe explain to our jurors, what's the motion? I don't know, they might not understand. What is that?
I don't think he filed anything before the trial, but he made mention about doing so maybe during the trial.
On the trial?
I'm not really sure what he was doing, but I don't think he had filed anything yet.
Okay, so-
Other than that motion that I was hearing, I don't think there was anything against me. I'm not trying to correct you, but
No, I'm
that's
talking about the
my
motion right before that traffic trial.
Yes, but a motion is a request of the court to do something. For example, in his case, I think it was to dismiss all charges because his case did not go to trial fast enough because maybe it was continued once before. And they had several other things like something about his religious beliefs and a few other things. And I remember that because it was on the trial, so I have as good a memory as everybody else watching for the most part.
Right, basically, so it isn't, so a motion is something, right?
Motion
Basically a request to the court, the judge to
yes, Your
do
Honor.
something to make a decision. Okay,
Yes, sir.
in that context. And then one of the other things that maybe I just want to make that are you said to him, I believe he said something and you sort of stopped him and said, you've made your record. I just wonder, what do you mean by that, just so our jurors understand? Like when you say you've made your record, what do you mean by that?
Well, I mean, you want to get out on the record in case there's some kind of appeal. Things that you say to protect yourself. In other words, if you don't object to something that shouldn't have been said, then later on, if you make an appeal, you really can't complain about it and get the ruling reversed. You want to make your record.
Thank you,
have
Jeff.
the arguments in case, for example, in federal court, in case of the Ninth Circuit.
This is so awkward.
Transcript, audio, video recordings that we probably have here today.
It's an attorney asking another attorney questions that they both know the
You wanna
answers
have a
to.
record of things so you can go on if you lose at the level that we're
It's for the jury, but I'm dying inside listening to it.
And so now, obviously, so we saw that. And we
I don't know.
Then to April 8th, where April 8th, 2019. Mr.
Well,
Blandino goes to.
He did go to jail for not complying with his
And was your testimony
competency
that
exam.
day in your office?
I was in my office, yes.
Okay. And
Thank
what
you.
is your instruction to the receptionist, tell her that you're not gonna meet with him, or that you weren't there, or what exactly, if you recall, what was your?
It could have been any of those. The bottom line is, I'm not gonna deal with this right out. If I talk to somebody that I don't know, and they get a hold of an attorney, you're not gonna get them off home for a while. I have an obligation to clients that I'm dealing with right now. So something along those lines, it could have been get rid of them. It could have been anything. It's like, hey, I can't deal with this right now. I don't have anything scheduled. And I'm sure I was doing at least 5 different things at once for clients that I'm obligated to handle their tasks for.
Okay.
Civil litigation, you usually have stacks of paperwork on you. You have a big desk, and you also have things on your floor, because you have different things that are kind of looming, so to speak, getting phone calls, writing briefs. So it's a lot of, as opposed to criminal, it's a lot of paper. A lot of papers.
And a lot of juggling, balls in the air at the same time.
Multitasking, I like to say. You gotta be a good multitasker in civil litigation and criminal.
I'll be right back.
Okay, and, okay. So, and as you recall in that April 8th letter, that he said he came to you because his, or something to the effect that his religious beliefs required him to do so. You recall that?
Whatever the letter says is what it says.
Okay.
Yes.
And, I mean, I think he used the words probably negotiate a settlement, maybe he wanted to sound, I don't know, more formal for you, but, I mean, really, I guess if you put that letter in context with later talking to him, I mean, you get the impression, or is it your impression that he really just wanted to sit down and talk to you?
No, I never had that impression at all. I
Okay,
felt like he wanted to get at me.
okay, and you say he wanted to get at you.
He's a disgruntled former defendant. I mean, in criminal cases, as you're aware, there's a winner and there's a loser. And the losers will never be happy with the results. Sometimes they're okay with it. They just have their day in court. And obviously, people that don't prevail, they have their remedies. They go and make these complaints. They can contact the judicial, the Commission on Judicial Ethics, excuse me. But you don't go after the judge outside court. That's not part of anything that, to me, any reasonable person would do. I certainly would never do something like that if I was in front of a judge and I wasn't happy with the ruling and I thought I did something wrong. Never in a million years would I go looking for that person's work or possibly home.
But also, you are a licensed attorney of 25 plus
Now,
years as well. I mean,
26.
it does make a difference.
What do you mean?
Well, I mean, as your way of thinking as opposed to someone who's not an attorney licensed lawyer.
You know, I've heard thousands of cases. I've represented thousands of clients. This is the one and only time that this has happened, so I wouldn't agree respectfully.
All right.
This is an outlier, counsel, so I mean, not to argue with you, I apologize, but.
Yeah. So. So
Thank you,
basically,
Susan.
So you didn't contact him at all after the April 8th?
No,
Right?
I want that person away.
And it was your testimony that was, I believe it was that day or next day, it was the next day you said you went to file a police report?
Thank you, Andrew. That is
Yes, I
very
did,
generous.
along with other things too, like telling people of the city, watch out, there's a rogue defendant around.
You law talk while you
They're coming after
plow?
the pro tem. What about
That's
the
interesting.
Real judges that are full-time, where they're there every day. They're there once in a blue moon.
All right.
Shouldn't say that, sometimes it's more frequently, but I'm not there that often. Like you are here.
And,
I got to pause this again, though. This is exactly what I foreshadowed yesterday when I was talking to Natalie. That's exactly the defense I would put on. I would say, yeah, this is strange behavior, but he doesn't know any better, and he didn't mean anything by it. That's a tough defense to get around. Because what they have to prove is sort of subjective, and that's what's hard about this case, and that's what's making it really interesting for me. That plus, some of the antics, obviously.
okay, you said you've been a pro tem judge since 2001?
Justice Court, I started in 2001, that was my first appointment, and municipal court was 2000.
Oh, yes.
Okay. And.
But if he was pro se, I think he'd be in contempt right now. I think it'd be over.
Can you explain to our viewers what's the difference between a justice court and municipal court? I mean, municipal court is the court for city of, well, in this case, the city of Las Vegas. Is that correct? That accurate?
Municipal court is for the city, it's only misdemeanor cases, and it's only criminal or I guess traffic matters. In justice court, that's where all cases start that are criminal, whether it's a trespass case or whether it's a battery, use of deadly weapon, or murder. They all start in justice.
That's another thing that I found fascinating. I'm sorry, because you guys are chatting and it's interesting to me. It's the one thing that really has struck me in this trial so far, and I haven't seen all of it, but the bits I've seen is how cooperative Kim is with his counsel. He seems fine. He seems happy that Ben's up there. When the the prosecutor was giving his opening, he was like leaning over and chatting with his attorney. He's been very cooperative, and I did not expect that.
Justice court or.
Okay, and that's one by the county, right? I mean, these are-
Correct. Those cases go up to this level afterwards.
Right. Okay, so there's different sort of, what do you call it, government entities, I guess, that oversee each court.
It appears, I don't know.
City, justice court of the county.
Yes, like I was saying, I'm direct. I'm appointed by the city for municipal court, which was this case, and I'm appointed by the county commission for my justice court roles.
All right. And we had already, I guess, first as the courtroom is a public forum, so when Mr. Blandino was within his rights to go into your courtroom on April 25th. Was he not?
Absolutely not after he sent me that extortion letter, no way. Not in my eyes.
All right.
You obviously disagree, but no way, I mean. as you
I'm
saw
still
in the
here, by the
video,
way.
I mean, I'm usually pretty firm but fair. I stopped and I think I
He
studied.
wasn't being disruptive, he just came and sat down, he wasn't.
The fact that he came in after that letter he dropped off, threatening letter, and me knowing a criminal investigation was going on, that was certainly disruptive to me. I mean, obviously nobody else knew except that I kind of froze for a second, as you saw in there, but to me, it was extremely disruptive. I was at a loss for words and I couldn't even speak to the defendant. I was so thrown out by the fact that this individual, after having the nerve to come after me at the office and suddenly show up at a courtroom that I'm almost never in. That was extremely disruptive to me. And that's why you gotta go. I mean, you can't be trying to extort.
You gotta
somebody
go.
And then show up in the courtroom. And I have
Like,
that right.
outta
to
here.
remove them. And I didn't so forcibly. I didn't ask for marshal or say, you're in my courtroom, you're in contempt. I mean, my response was, I think like anybody would, the reason why you gotta go. You know,
Artie, I see in the comments, the way you said it to me, you were going to start at 7 p.m. my time, 6 p.m. your time. But just tell me if you want to get started, and I can close this down. We can migrate over there.
get out of here. I mean, I was concerned. Okay. There are defendants sometimes in cases that try to come at the judge, and anything can be used as a deadly weapon, as you know.
But I mean,
You guys had-
there's a rigorous screening process here to enter the Region Justice Center.
That depends on
Correct.
counsels for firearms and knives.
Okay, and I mean, you have armed marshals in your courtroom.
Usually one,
Okay,
and the one might be sitting over there, and
okay.
I stay on a first name basis with the marshals just so that they know if I say their first name, they know I'm reading somebody wrong and there might be a problem, and then they, that's kind of what.
Okay. And, but I mean, were you frightened or what were you, what were you saying? You froze when he came in on the 25th?
Well, the person coming to my office once that I never had happened before, that was obviously
No, they're constrained.
horrible. But then the fact that he found me in court randomly 2 or 3 weeks later and showed up, certainly was no coincidence in my mind, because I'm not sitting there every day. My office is where he found me way up on the northwest side of town, not down here. So probably was the next time I sat after that was over there, and that was kind of more frequent. I usually sit because I have a full-time job.
How frequently do you sit for your
Sometimes it could be a few mornings or something in a row if somebody's out sick or there's an open spot, but.
We were, but
usually at most,
that was scheduled for later.
on average, sometimes you can go 6 months without sitting.
This was my prep for that.
In general, it's very infrequent. However,
a month, you said?
I would say on average, if you looked at all the sittings once a month, you could have like 3 mornings or morning and afternoon. It varies, but on average.
Yes, I know.
We would say.
The audio just went down the hill. Is that better?
I had more time on my hands, probably once a month was an average.
The audio is
Some weeks,
nothing.
maybe twice in 1 week.
And it dropped
Some
while
months,
we were
Not
on.
at all. So I'm comfortable saying that, but I'm not 100% accurate, probably even 75% accurate on that.
And, so then going to, so then obviously we heard your testimony of him dropping off the letter, which led to you calling him, I believe it was on April.
Artie, I sent you a link. Pop
Sounds
on.
right.
If we're going over there, we can do that, but it'd be easier if we just talk. It's not a problem.
Sorry. It's a little distracting.
All right, and, well, you said you did not want to call Mr. Blandino, is that correct?
Oh, no. I mean, yes, it's correct. I absolutely did not want anything to do with this individual.
And so but you called him at the insistence of the marshals, of the detective and the marshal.
They didn't insist. I mean, they asked for my cooperation. I'm the one that started the process. Of course, I'm going to cooperate. Otherwise, it's going to be in.
So you did so then at their request, maybe not insistence, but at their request.
To facilitate their investigation, I guess is a better way to put it.
Okay.
Yes.
So-
I didn't do it because I wanted to or because it was my idea. We'll put it that way.
Oh, so the idea to call Mr. Blandino came from these law enforcement. Okay.
Right. You can imagine the call after seeing the trial, how much he talks.
Yeah, and so when you, I believe you, it just when it was that he was, I guess he was surprised when you called him? Is that how you categorize it as?
I would say delighted and giddy.
Okay, I believe you said giddy at your grand jury testimony.
I didn't.
I believe you did, use that word giddy.
That was a couple of years ago. I'm just telling you what I remember. I can hear him, but obviously I'm not going to, I mean, I've had thousands of telephone calls,
Right,
but
but never one quite like this, where you've got,
right.
marshals sitting in on you, I mean, as soon as the price did out.
He repeated at least 3 times, I cannot believe that I am speaking with Michael Federico. And you could just, just like reeling in the fish, those telephone scams. It's just a matter of, okay, he thinks he's got one over on someone. Finally, after whatever all his attempts, that's what it sounded like. I'm not saying that's true, but that's what it sounded like. And, I remember I kept shaking my head at the officers. I'm just like, because it's humiliating knowing that he thinks he got one over on me like that. It's just, if it's a blow to any ego you might have, it's embarrassing.
But I mean, I'm told you that, I mean, he's made he's written these letters before, but no one has ever called him back, right? Did you mention that? Do you recall that?
Something like that, he was very impressed with himself that finally his scam had worked. That was my impression, for lack of a better word.
Okay. And, I mean, so he said that every prior incident the judge previously had just ignored. You recall him saying that?
No, I don't, sorry. I apologize.
Well, I mean,
I didn't hear the question, counsel, I'm sorry.
okay, so I mean, he indicated on the call that whenever he'd written these letters, but every prior incident he was just ignored.
I think so. I can't swear to it, but he probably said it. I don't have an independent recollection.
Okay.
Something
That would probably
like
be
that.
consistent with the types of things he was talking about on that call.
If one of the officers testified to that, I would be 100% agreement with it. Because they were paying more attention. I was just kind of focusing on the goal and hoping to get off the phone with this guy.
But in fact, they were taking notes. Did you observe the officers taking notes of the call?
I thought maybe there were, but, years later, all I remember is, I didn't remember, I found in my folder those 2 pieces of paper that you were able to see with your notes that I read.
Yes.
I forgot the exhibits. But I'm sure that they were because they had to keep track of what was going on. I just wasn't paying attention to it so well. All right. Those are the originals too, obviously.
Correct. So I'm showing you, if I'm approaching, showing you what's been previously marked and entered into evidence. as
No.
State's Exhibit
I haven't.
33, 34. Thank you. And glasses. And do you recognize those as the notes that the detectives gave to you?
Yes.
Okay. And so they were,
It was kind of passed by. I'm sitting on one side, I think they're on the other side, and the phone was in the middle. And either they were showing me or passing back, and then I would pass it back and put my my hands up in the air because that wasn't working and then something else to be written. That's kind of, it was a fluid process in an effort to get more information from the client.
Okay.
So that's the way, I remember that. I was
So this
really
is-
nervous.
You can do that
One of the notes there.
in 1 minute.
Read that and then,
You want me to read both of them, sir?
well, I mean, sure, well, looks like there's two questions there. Been written in, yeah. There, number one,
What are your terms of settlement? And number two is, what do you want to see happen?
okay, so you, on this call, you asked the questions that they told you to ask, is that correct?
Yes, or try to put my own spins, or I might not say exact quotes, but
Well,
I got,
to this effect, I mean, you,
I'm,
but that's, you understand what I'm trying to say? Maybe not verbatim, like, what are the terms of your settlement?
they are the pros, they are the experts, and I'm trying to follow their advice. They're trying to help me so that we can make this a one telephone deal, because they knew I didn't want to make that first phone call.
Right.
That's what was going on, is I'm throwing up my hand saying, hey, he wants to meet in person, what am I supposed to do here?
Right, and I believe you just by the, yeah. Okay, so you, say that again, you want to make this a one phone call deal?
No, I did not want anything to do with your client, I just wanted him to go away.
Yeah, neither do I. Okay, I'm going to close this down. I just got a request. He was charged with extortion, and what he's doing is he's making threats to this Judge Federico, who was on the stand. He's also charged with impersonating a law enforcement officer or something like that, because he says he's part of he's a volunteer judicial inquiry guy, which he's no, well, I mean, I guess he is in the sense that he volunteered, but nobody asked him and he has no association. I really appreciate, this was actually really fun. It surprised me. I was waiting for a moment, but there's just so much going on with it that I was going to give you guys more of my thoughts on it. This is dovetailing with the opening arguments. I just a little bit ago was looking at the opening arguments because I was gonna do a video on the opening arguments, but I didn't have them available. I probably still will do that. But it's interesting to watch this testimony. The opening arguments, you sort of give a roadmap. You say, okay, here's what the evidence is going to show. And here we are in the midst of the evidence. We've really had one witness of substance, which is this guy, and he is the guts of the case. I think they're both doing fine. I think the state has made a prima facie case that for extortion, but I think Ben is sort of poking holes in it and saying, hey, my guy's just sort of dopey and he really doesn't know what he's doing. You can't take any threats from him seriously, thereby knocking out a prong that the prosecution has to prove in order to get him convicted. We haven't gotten anywhere with the impersonating an officer or a judicial, thing, whatever that charge is. He's trying to act like he's official, like he's got some capacity, and he doesn't, and that's a violation. So those are the two main charges that are before us. His conduct is not good. That is clear. Does it rise to criminal beyond a reasonable doubt? That's a tough question. That is a tough question. You definitely want what he's doing stopped, but can you prove it beyond a reasonable doubt as written in the Nevada Code and charged by the prosecutor? That is not easy. All of this was Artie had emailed me earlier and said, I'm going to do a stream, and that's why I'm stopping this now. I'm going to do a stream. Of course, the time zone thing messed me up. I thought it was going to be starting 7 my time, but it looks like it's going to start 5 my time, which does make sense. So I'm going to get off here, and because Artie came on. I invited him on, but he didn't come on. I was going to have him discuss that and promote his stream, but I'll do it here. That's where I'm headed. Assuming Artie sends me a link, I'll be headed over there to do a little bit more of this. I literally sat down and thought, I haven't seen much because I was really busy today, so I hadn't seen any of this trial. I did have the opening arguments, but that's old recording in the background, but I wasn't really watching it. And I thought, well, let me get up to speed so that when I go on the stream, I'll know something. And then once I had it up, I thought, well, why not just go live with it and see you guys, which I'm glad I did because it was really fun. Thank you all for coming out. Hopefully I will see you all in just a few minutes over on Artie's stream, and we'll pick it up from there. Thanks.